Yankee was the last iteration.
Correct. When we were handed 456, I think we must have assumed.
Now, wait a minute. You just assumed the paperwork was correct and negotiated a 30-year plea?
And I'm not going to go into it, but the subject matter of number 8 in this is different than what number 8 in 456 is.
Hendrick's attorney.
Well, that 455 was what was being handed to us to execute. And we did not notice not 456 with that additional number 8 embedded in the factual allegations.
Hendrick's attorney.
I don't have an acceptable explanation as to how we missed it.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep.
What's up, YouTube family? Welcome back to the channel. Before we dig deep, man, y'all go ahead and smash that like button. It really helps the channel grow and allows me to continue bringing everybody this exclusive content. Y'all ready? Let's dig. Now, the state's case has definitely been falling apart and crumbling even before they put this witness on the stand. But this witness definitely didn't make it any better for the state. Now, with the tensions in the courtroom boiling over from the witness on the stand, the lead DA is actually going head-to-head with the witness attorney. The irony is that the lead prosecutor has been in her feelings since the witness on the stand that they keep introducing are actually backpedaling out of their pleas. But here's the shocking twist. Did the state actually secretly change the terms of the plea after the plea was signed? Now, the irony is the public defender is saying that the plea deal that the witness agreed and signed was actually done, but it's definitely completely different. So was this a last-ditch effort by the DA for another cover-up of their own mistake, or is there something much bigger at play? Y'all make sure y'all stick around to the very end so we can see how this plays out again. And as always, don't forget to like, comment, and subscribe if you're feeling the content. Y'all ready? Grab a seat. We finna dig deep.
Attorney.
Do you, looking at 452 Yankee, is 452 Yankee, did you say earlier that that accurately reflects an email sent to you on December 27th?
I did. But I'm looking and thinking there were at least 4 versions, but there might have actually been a little bit more. But when I'm looking at what I thought was the first version, which is what I thought my response was to, it looks like this may have been an updated first version, meaning I'm just seeing some slight differences. That's why I'm hesitant to just say, yes, that this is it. I can't say, is this iteration that was in that process of getting us to the end? Yes. All right.
Are you able to say if there is any material change from the number 1 under the factual acknowledgement section from 452 to whatever version you're looking at that you think you might have been responding
To jump
just number 1 under factual acknowledgments. Number 1.
Okay. Number ones are
Don't
one
say
is
what it is.
one is the same.
Okay. My only question relates to number 1.
Okay.
All right. And so as it relates to number 1 on the factual acknowledgments that you were responding to when you sent 460Y, is that number 1 the same as in 452Y?
Yes.
Is that the same in the document that has been admitted as 1AS in a prior hearing?
Just to. Yes.
And is that the same as number 1 on State's Exhibit 444Y?
All right, we already established that 1AS and 444Y are the same document, so we don't need to ask that question for all of them.
So as you read over and initialed 1AS with your client, I'll take this.
Yes.
Did you come out, did you ever speak to the state about number 8? To the best of your recollection, did you request that number 8 be removed?
No, I did not. I have no recollection of seeing number 8. I understand my client initialed it because I can see his initial. I also understand it may have been enunciated by the state at the plea, but where we went from 455Y, where it was not in there, and then it was in there, I don't know how it got there or how we missed it.
Now, first of all, let's get into this plea deal. Now, it's interesting that this attorney, who's been on the actual case, 15 years, said that they know Sled, they've had a relationship. But ironic, is it coincidence that in the middle of this RICO trial with all the multiple negotiations, the possible or alleged paperwork changed up, all of a sudden now, this was overlooked? We read it, but we missed it? Man, did Sled actually just get railroaded by the state and by the public defender? Remember, in the court of law, business is business. And please, someone explain to me, how do you negotiate a plea to 30 to 35 years? Make that make sense. Let's dig.
Attorney.
Because neither my client or I appeared to have realized it was there, and it came in.
Are you saying that you did not read this document before you all signed it?
No, I reread it and signed it. I can't dispute that. But
And-
how that number, when that was something from the very beginning we were contesting, I can only say we missed it, and it's in there.
Man, hell no.
And when you say you were contesting it, how are you? How did you contest it? Without saying what you said, but how did you contest it?
Well, by telling the state that information, that's the subject matter of that, is not something that he has knowledge of or information on. So I'm sort of hamstrung to answer your question.
All right, we'll come back. And so at the time that this document was being read into the record, were you paying attention?
I was paying attention, but I missed it. So apparently not good enough.
Now, what's interesting is that Ms. Love, of course, said that the paperwork was not changed, and these have been the facts in the paperwork. But is it not interesting that the attorney is sitting here doubling down right here in front of the jury and the defense, as well as the judge, saying, no, this was not in the paperwork. And when we asked to put it here, it was removed, but then replaced, and then now it's back. But potentially after the deal was signed? Man, come on, man. Is the state railroading the defendants? Now, I've been saying from the longest the state set these pleas up to actually railroad the defendants in the end. So 30-year probation plea, you might as well go sit down. There's not too many people that can literally have no incidents on a 30-year probation. If you step up in the state that you're in, they have you locked into the city, locked into the system. You can't move. So ask yourself, how much sense does it make to actually accept a plea deal to be on probation? Still award another state. Psh, make that make sense. And what does attorney mean? He overlooked it. It was bust the me. Stop, bro. Why y'all just tell the man the truth? He couldn't afford the counsel, so he got what he paid for. Let that sink in. Let's dig.
It's attorney.
Just as when I went over it with my client, which I did. I'm not saying I didn't, but that is something that to this, I mean,
But
it's sort of
I was always
the
taught about
surprise
the
of this
gate,
trial
so
for me.
that mean he just
was
lied right there in
that
the
was in
stand.
there, and how did we
But-
miss it?
And when you speak of
They played.
that was a
That's all it
subject
is.
matter,
Just tell the man y'all
beyond
played.
it
Tell me y'all
being
played.
something you referenced you said you saw it referenced in 452 Yankee number 4,
Mhm.
and you saw it in 456 Yankee as number 8, the final iteration. Is that fair? Did I get
Correct.
that right? Okay. Do you have notes, or do you have an email or a text message or anything that reflects, hey, 456 or number 8 on this document, not the final, but number 8, take it out.
To answer your question,
Hell nah.
going back to when this was happening, when we saw 455, it was not in there, and everything seemed consistent with what we had asked. When we were handed 456, I think we must have assumed, and I don't want to speak for Mr. Sledge,
Don't assume.
well, that 455 was what was being handed to us to execute. And we did not notice because, again, it's an addition. It's a completely different sort of addition, and it's in there. And again, I'm not disputing it is in there, but I can't explain to you how we missed what we thought we were signing, or what I thought we were signing was 455, not 456, with that additional number 8 embedded in the factual allegations. And I don't have an acceptable explanation as to how we missed it.
Yo, stop what you're doing real quick. Hit that like button and subscribe to the channel. It's free. Hit the like button. share the video, hit the like button. Let's dig.
Okay, so looking at 455, and Your Honor, this is one of the last three questions I have. Looking at 455, is 455 Yankee number 8 what you're referring to when you said that you thought 455 Yankee was the last iteration?
Correct. And I'm not going to go into it, but the subject matter of number 8 in this is different than what number 8 in 456 is.
And so is 455 Yankee number 8 what you were trying to agree to?
Yes.
Okay.
So did the state actually change the plea deal after it was signed? Nah, of course not. Why would the state do that? They got all the evidence they need to already further the RICO, so why would they need to change the paperwork or make 5 different copies of the same plea or 5 different negotiated plea copies? And if, again, I'm so stuck on this, how the hell did the attorney negotiate a 30-year plea out of 5 different versions of a plea deal? Make that make sense. Now, ask yourself, what does this mean for the case? If the state actually did change the plea or the verbiage on this paperwork. It's not like he was reading it to keep up with it anyway. But at the same time, if they did do this, what's the impact to this actual case? Will the state actually still go after Mr. Sledge after all of this is actually over? Because he's still in violation of the plea. And if he is in violation of the plea, which ones? Or which one? Well, I guess the one that he put his name on. Ironically, of course, he can't recall which one he put his name on. Now, is this opportunity for the defense to actually sway everything around to the jury? Because again, this was actually just heard and displayed in front of the jury right after the witness got off the stand. So ask yourself, is the state playing the witness or is the state playing with the state? Now, again, you have an attorney who does not receive any funding from his actual client, which means he's technically a public defender, acting out of friendship or relationship over 15 years. But at what point is enough enough? And it's 2024. How many people are actually out here working for free? Let that sink in. That's deep.
It's attorney.
Based on your notes, what iteration did the date and time that number 8 first appeared in?
Well,
based on your notes and without saying what number 8 is.
Understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
And so would you tell me, or the jury rather, what iteration between states 450 and states 456 and including states 452, what iteration of that agreement did number 8 first appear in? Just by date and time and exhibit number.
Sign it, I'll sign it, then I'll present it to you and then get your signature.
Okay. Was there any material addition that you asked to be included in State's Exhibit 1AS that the state refused to include?
There was no addition, no.
Okay.
Or rather, let me say this, no addition that we asked that was not included.
Okay. Was there something you requested be taken out of the plea agreement that is a part of State's 1AS? And I stopped that question right there for a reason. Is there something you requested be taken out?
Yes.
And is it contained within a number?
Number 8.
Okay. And at what point did you request that number 8 be taken out?
Even in the very beginning in my initial email, we were given an indication that he did not have information.
Wait a minute, you're getting into it. I'm asking you about a time frame, just the time frame, because of
from the very beginning.
Okay.
That was one of the things that was an issue for us.
Was number 8 included in any previous iteration
I would
before States 4? based on your notes,
Mhm.
what iteration did the date and time that number 8 first appeared in,
Well,
based on your notes, and without saying what number 8 is?
understand. And let me work my way backwards. I'm going to look through the earlier iterations, but I can tell you the one before this exhibit, which for my records was iteration number 3. It was not in there. So the subject matter of number 8 had been removed from earlier versions, was not present in iteration number 3, such that it appeared again in iteration 4.
Now, the big question on everyone's mind should be, will the judge actually intervene? Now, as you saw, Ms. Love and the actual public defender went back and forth, but it is clear that this situation can't be ignored for too much longer. Is the state actually operating out of good faith or bad faith? We sit up and witness the state misrepresent evidence over and over and over again with no consequence. We see them come in with prejudicial evidence with no consequence. We see them come in with speculations and allegations with no consequence. Whether they're right or wrong, nothing happened. So is the state's case really based off allegation and speculation? And if they didn't have all these pleas from these defendants, will we even be here today? Let that sink in. And let's just keep it G. The prosecution has not had a good week since they brought these witnesses up on the stand. Just imagine how the jury sees this. The lead attorney from the state going back and forth with another attorney that works for the state off a misrepresentation of information. Man. Not to mention, this is actually a repeated pattern of behavior with every witness that the state has on the stand. So is this case actually going further, or is the case actually crumbling in our face?
Attorney.
Yes.
Now, the state's entire case is supposed to be surrounded and acting around good faith. But ask yourself, is this a moment or an opportunity for the defense to actually prove that the state operated out of bad faith? A 30-year plea, that was just exposed. The conditions of his plea were just exposed. The terms of his plea were just exposed. The situation that led him to the plea were just exposed. And now y'all saying y'all changed the paperwork? Phew. Definitely an opportunity for the jury and for the defense to actually counterstrike the prosecutor's entire case. Again, has the prosecution introduced a witness that actually helped the state? Not to mention, y'all know we about to break down this expert that they brought in to look at the infinity. That's a whole nother video that is coming next. But this is all about the state finessing the state. The state finessed Sledge, and Sledge just got sledgehammered. So the ironic thing is there a way that he can get out of this? Or is this just what it is? Unfortunately, when you put your name on that paperwork or that dotted line without reading that contract or reading that fine print, this is an example of exactly what happened. And it always makes you feel sad for them. But then again, a lot of these guys actually put themselves in that position for not standing on business in the county as they were allegedly standing on business in the streets. Let that sink in. So what about the jury? Now the sick reality is, if all of this is playing out in front of the jury, this could definitely damage the state's case even more, especially when it comes to the prosecution's credibility. Now, if we're sitting here and we're watching the jury's having to question whether the state is actually using foul play or foul tactics just to secure a conviction, ask yourself, did the state just fumble the ball again? And then you turn around and have a plea broken down. And it's, hey, the paperwork's been manipulated. And then at the end, even with the negotiation, y'all negotiated 30 years? Phew, that's deep. Who changed the paperwork? Or did the attorney just have an honest mistake? And at this point of your life and in the case, can any one of these defendants actually afford an honest mistake? Let that sink in. Man, y'all jump in the comments, let me know y'all's thoughts. Did Sledge just get played, or was this just a bigger play from the state? Y'all tap that notification bell so you don't miss that drop whenever I drop. If you're not subscribed, man, subscribe to the channel. Jump in the comments, let me know your thoughts. Whether you for the case or against the case, for the state or against what I said, either way, hit the like button. Jump in the comments, let me know your thoughts. Till next time, y'all remember mine. The life you save might be your very own. In this case goes to show, move on your own. Until next time, it's your boy Jay.
Attorney.
Gone.